So do you guys remember Mark and Patricia McCloskey? It's this couple from the summer of 2020 who confronted a group of protesters walking through their neighborhood by standing outside their home pointing firearms at the protesters. Well, it's now being reported that they may face suspension of their law licenses. So I asked my staff, and I'm happy to report that we were able to find a copy of Mark McCloskey's disciplinary complaint. Why would Mark and Patricia McCloskey be facing a disciplinary complaint? Well, they are both lawyers, so they are not just subject to the laws, they're also subject to the rules of professional conduct, which is usually what they're called, the standards for being a lawyer in your state, wherever you're licensed. And this complaint is now going to explain how they violated those standards and why suspension is the appropriate remedy. In the Supreme Court of Missouri comes now Chief Disciplinary Counsel. Respondent is Mark McCloskey. He was admitted to the Missouri Bar in 1986 and assigned bar number 36144. His license is in good standing. He has no disciplinary history. On June 17, 2021, respondent pled guilty to the Class C misdemeanor of assault in the 4th degree, admitting that he violated Missouri law by purposefully placing at least one other person in apprehension of immediate physical injury by waving a Colt semi-automatic rifle in the direction of one or more individuals in front of his home in the city of St. Louis, June 28, 2020. On the same date on which he pled guilty, June 17, 2021, respondent was sentenced to pay a $750 fine, and he was ordered to forfeit the Colt rifle. Before accepting his plea, the trial court asked respondent several questions, including this: and it is true that on that date, time, and place in question, you placed a person in immediate physical apprehension of immediate physical injury by waving the Colt semi-automatic rifle in the direction of one or more individuals? Mr. McCloskey responded, "I sure did, Your Honor." Now, I don't know with what inflection he said that, but "I sure did, Your Honor," as a response to, are you pleading guilty to this crime? Did you point this gun at people? "I sure did, Your Honor." Respondent also acknowledged hearing the special prosecutor describe the events in this way: "Judge, if this case were tried, the state's evidence would show that on June 28th of 2020, a group of protesters were headed north on North Kings Highway, and some of the group, they were on their way to the mayor's house to protest some information she had released, and some of the group thought they were taking a shortcut. They turned left and went down Portland Place, and as they confronted and the McCloskeys, when they saw the crowd coming down into the gate in front of their house, they went outside with guns. The charge against Mr. McCloskey is that, again on that date, he purposely placed at least one individual in apprehension of immediate physical injury by waving a rifle in the direction of one or more individuals in front of his home. That is an assault in the 4th degree, a Class C misdemeanor." Respondent, Mr. McCloskey, told the trial judge that he understood that the prosecutor would have to prove his guilt beyond a reasonable doubt, that he could bring witnesses and make arguments to convince a jury that he was not guilty. He also told the trial judge that he understood that he was giving up all these rights. When respondent pled guilty, he admitted the purposeful criminal conduct of placing others in apprehension of physical harm by waving his automatic rifle in their direction. When he pled guilty, respondent waived any defenses he may have felt applicable to his circumstances. In other words, by pleading guilty, he admitted that he was not lawfully defending himself, other people, or his property. By pleading guilty, he also admitted that he was not executing any public duty and that he was not authorized to make an arrest. Finally, by pleading guilty, respondent admitted that his purposeful conduct was not justified. Any statement that his conduct was justified is contradicted by his guilty plea, which was made after consultation with counsel and after questioning by the court. As the court noted in 1997, when a Missouri lawyer received a suspended imposition of sentence following a guilty verdict for felony assault, quote, "Whether the attorney successfully completes his probation or he violates his terms and his sentence is imposed, the conduct of which he was found guilty warrants an evaluation as to his fitness to currently practice law." The court added, "Mr. McBride may not relitigate his guilt or his defense of self-defense in this proceeding." For many years, this court has ruled that guilty pleas admit the elements of crimes and waive defenses. A plea of guilty and the ensuing conviction comprehend all of the factual and legal elements necessary to sustain a binding final judgment of guilt and a lawful sentence. By entering a plea of guilty, the accused is not simply stating that he did the discrete acts in the indictment, he is admitting guilt of a substantive crime. Consistent with these principles, the general rule is that a guilty plea waives all non-jurisdictional defects, including statutory and constitutional guarantees. Respondent admitted committing a criminal act that shows indifference to public safety and involves moral turpitude. This court has defined moral turpitude as an act of baseness, vileness, or depravity in the private and social duties which a man owes to his fellow man or to society in general. Missouri lawyers have been disciplined under this rule and its predecessor upon conviction of misdemeanor assault and misdemeanor harassment charges. In these cases and in felony cases, the court determined that the lawyer's conduct involved moral turpitude. In the Frick case, the lawyer was convicted of the unlawful use of a weapon, a Class D felony. This court ruled that the lawyer's criminal conduct involved moral turpitude when he vandalized a college campus and then fired a gun towards campus security officials, knowingly placing these people in fear for their lives. Additionally, the court held that the circumstances surrounding an assault-related crime may establish an offense involving moral turpitude. In this latter regard, the court determined that the lawyer's harassing conduct, including sending vile and threatening letters to a former client, also involved moral turpitude. 9 years later, in another attorney disciplinary case, this court ruled that both misdemeanor non-support and misdemeanor harassment convictions constituted moral turpitude. So the Chief Disciplinary Counsel is trying to establish that all of these acts qualify as moral turpitude, so should Mr. McCloskey's. More pertinent to this case, the court described Mr. Warren's harassment charge this way: respondent's written and oral threats to his ex-wife and her husband speak for themselves. Respondent's written death threat and further threats that he would be waiting in the dark for the Kennards clearly involve baseness, vileness, or depravity. This court finds that respondent's convictions involve moral turpitude. In other reported decisions, the court has found moral turpitude when lawyers have been convicted of various misdemeanors: failing to file tax returns, seduction under promise of marriage, failure to pay taxes. In that one, the court relied on the lawyer's willful criminal conduct, noting that he was more than careless and that he voluntarily and intentionally violated the legal duty to pay taxes. The court has also applied this rule and found moral turpitude when disciplining lawyers for numerous felonies, including possession of drugs. In the following unreported orders, this court has decided moral turpitude was involved in various lawyers' criminal conduct. In 2019, a lawyer suspended upon conviction of 4 misdemeanors, driving while intoxicated, 3 related counts of third-degree assault, based on recklessly causing physical injury to another. The court disbarred a lawyer in 2016 upon his felony conviction for sending threats via interstate commerce. In 2014, a lawyer was disciplined upon 2 additional driving while intoxicated convictions and a careless and imprudent driving conviction. The court ruled that his crimes involved moral turpitude. The court disbarred an attorney upon proof that he knowingly had physical conduct with a minor causing significant emotional distress. 2007, the court suspended a lawyer upon conviction of a misdemeanor stealing offense. 1998, the court reprimanded a lawyer who had pled guilty to 2 assault charges. 1996, the court suspended a lawyer following a conviction of stalking. So the disciplinary counsel is really trying to show the court that pointing a gun at people is an offense of moral turpitude that should get your law license suspended. Application of this court's previous disciplinary opinions and orders dealing with lawyers guilty of criminal assault, harassment, and stalking, whether involving reckless, willful, or purposeful conduct, and causing distress and fear, establishes that respondent's criminal conduct involved moral turpitude. Opinions and orders applying the rule also support a determination that respondent's criminal conduct reflects adversely on his fitness as a lawyer. So then they explain why the matter is ready for review. He has been sentenced. The criminal case has finally been disposed of. However, Missouri Governor Mike Parson pardoned respondent on July 30th, 2021. The governor's pardon, according to the Chief Disciplinary Council, has no impact on these proceedings. In Missouri, a pardon obliterates a person's conviction, but the person's guilt remains. In that case, involving an application for a liquor license following a conviction and a pardon, this court addressed the following question. In the case of an application for an office or license which is prohibited to one who has been convicted of a crime, does a pardon reestablish eligibility? That court, in the Guastello case, relied on an earlier treatise noting, if character is a necessary qualification and the commission of a crime would disqualify even though there had been no criminal prosecution for the crime, the fact that the criminal has been convicted and pardoned does not make him any more eligible. The Western District Court more recently addressed a similar issue. That court relied on Guastello to affirm a circuit court ruling that prohibited a lawyer from running for an associate circuit court judgeship. Despite a governor's pardon, the trial court had disallowed the candidacy on the basis of the lawyer's guilty plea to 2 felonies when he was 17. The Court of Appeals noted that the statute prohibited candidacy by any person who has been found guilty of or pled guilty to a felony under the laws of the state. Like that statute, the rule before us permits discipline upon proof of guilty pleas, no contest pleas, or findings of guilt. No conviction is required, not even a conviction unobliterated by a pardon is required. Respondent affirmatively stated his understanding that he could not later take back his guilty plea. He admitted guilt in court and remains guilty. Suspension is the appropriate sanction. This court's reported and unreported decisions in cases based on criminal misconduct support informant's recommendation that respondent be suspended. The following cases resulted in suspension: reckless third-degree assault, driving while intoxicated, indefinite suspension with no leave to apply for reinstatement for 6 months, no probation. Third-degree assault in a poker game fight, driving while intoxicated, indefinite suspension, apply for reinstatement after 2 years, with probation. Stealing, indefinite suspension, can apply for reinstatement after 6 months, no probation. Driving while intoxicated, careless and imprudent driving, indefinite suspension, 6 months, reapplication, no probation. Criminal non-support and harassment, 6 months, no probation. Stalking, indefinite suspension, 2 months, no probation. Endangering the welfare of a child by failing to seek medical attention, indefinite suspension, reinstatement, 1 year, no probation. And they continue like that. In a 1997 decision split over sanction, the majority of the court reprimanded a lawyer found guilty of second-degree assault following a shooting on his property. The 3 dissenting judges would have suspended the lawyer. The following year, the court reprimanded a lawyer convicted of 2 misdemeanor assaults. Upon a conviction for a felony harassment related to knowing physical conduct causing distress, the court disbarred the attorney. The court disbarred an attorney upon conviction of a felony of communicating a threat through interstate commerce. The court disbarred an attorney for firing a gun toward a campus security guard. We saw that in Frick. The court routinely considers the ABA standards. Those standards anticipate that courts will generally look to the duty violated, the level of intent, the harm and potential harm, and then weigh any aggregating or mitigating factors. Here, respondent violated duties of the public and the legal profession. He admits that his conduct was purposeful. His crime and his post-guilty plea statements brought discredit to the profession. The court generally considers ABA standards 5.1, 5.11, 5.12, 5.13. Standard 5.11, disbarment's appropriate when a lawyer engages in serious criminal conduct, a necessary element of which includes intentional interference with the administration of justice, misrepresentation, fraud, extortion, theft, or if the lawyer engages in any intentional conduct involving dishonesty, fraud, deceit, or misrepresentation that seriously reflects on the lawyer's fitness to practice. Suspension is appropriate when the lawyer engages in criminal conduct which does not contain the elements listed above, but that seriously reflects on their fitness. Reprimand is generally appropriate when a lawyer knowingly engages in any other conduct that involves dishonesty, fraud, deceit, or misrepresentation. Next, the Chief Disciplinary Council discusses the mitigating and aggravating factors. The mitigating circumstances include that McCloskey has no previous discipline and he has cooperated with the disciplinary authorities. The aggravating circumstances include the statements he made to the media after his guilty plea. On the courthouse steps, immediately following his sentencing, he publicly declared, quote, "The prosecutor dropped every charge except for alleging that I purposely placed other people in imminent risk of physical injury. Right, and I sure as heck did. That's what the guns were there for. I'd do it again anytime the mob approaches me. I'll do what I can to place them in imminent threat of physical injury because that's what kept them from destroying my house and my family." Minutes after admitting in court that his behavior was not legally justified in that setting, he told the news media that he would commit the same crime under the same circumstances. He repeated and expanded his comments in a national news television interview over the next few days. Quote, "That's what the whole purpose of the guns was, to stand out in front of the house, make people back up, put them in immediate fear of physical injury. That's what kept them from killing me and burning down the house. And it's kind of hard for me to say that I didn't do that because that's what I did. It's kind of a, non-event Class C misdemeanor fine. It's a, a little face saving for the prosecution's office." Respondent's public statements aggravate because they indicate his refusal to acknowledge wrongdoing and demonstrate his lack of respect for the judicial process that he had recently participated in. A lawyer's conduct should conform to the requirements of the law, both in professional service to clients and in the lawyer's business and personal affairs. A lawyer should demonstrate respect for the legal system and for those who serve it, including judges, other lawyers, and public officials. While it is a lawyer's duty when necessary to challenge the rectitude of official action, it is also a lawyer's duty to uphold legal process. In addition, a lawyer should further the public's understanding of and confidence in the rule of law and the justice system because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. The Tennessee Supreme Court recently imposed a 4-year suspension against a lawyer who publicly counseled a non-client on Facebook about how to commit a violent crime using the Castle Doctrine as a defense. Finding a violation of Rule 8.4d, conduct prejudicial to the administration of justice, the Tennessee court found an aggravating circumstance was that the lawyer made his comments so publicly. Quote, "Here Mr. Sitton's choice to post his comments on a public forum amplified their deleterious effect. We can think of few things more prejudicial to the administration of justice than publicly fostering a view of lawyers as co-conspirators whose role is to manufacture plausible but untrue defenses against criminal charges for the premeditated use of deadly force. It promotes a cynical view of the justice system as something to be manipulated instead of respected. Moreover, while the danger to the target is obvious, had Mr. Houston followed Mr. Sitton's instructions, the public venue for Mr. Sitton's bad advice created a risk that others would use it as well." In this case, the McCloskey case, respondent's repeated statements to the media that he would do the same thing after admitting in court that his conduct was purposeful and criminal also amplified the deleterious effect that his crime itself had on public perception of the legal profession. As in the Tennessee case, the Sitton case, this respondent's statements to the media on the courthouse steps in a national news interview created a risk that others might follow his lead. Wherefore, informant, Chief Disciplinary Counsel, prays the court order respondent to show cause why his license should not be disciplined based on his misdemeanor conviction of assault in the 4th degree. Additionally, informant prays that the court, upon finding he has committed professional misconduct, enter a final order of discipline with a recommendation that respondent's law license be indefinitely suspended with no leave to apply for reinstatement for 6 months. And that's Alan Pratzel, Chief Disciplinary Counsel. It sounds pretty reasonable to me. You are not supposed to point guns at things that you aren't prepared to destroy. Protesters outside your house, sure, that's scary. I get that that's some level of scary, but I don't think that that allows you to escalate to deadly force or threat of deadly force. When we talk about response to a threat, it should be sort of a one-to-one response, a non-escalating response. If the protesters had broken into their house, probably some kind of castle doctrine applies. Maybe then it would be appropriate to fire the weapon at someone. But just waving firearms around at people because they're protesting and you don't you feel threatened, that's not reasonable. And that's not something the law supports either. So Mr. McCloskey pled guilty, and so he is in fact guilty of the offense, but then he was pardoned. But that doesn't change that he is in fact guilty of an offense. And so the Chief Disciplinary Counsel for his law license can use that guilty plea and the uncontested facts as a basis for a disciplinary complaint. And that seems pretty appropriate to me. If these are the standards that Missouri applies to their lawyers, unlike some of the standards we've seen that are applied by New York to Mr. Leibowitz, but if these are the standards that are applied to Missouri lawyers, then they should be applied evenly, and so Mr. McCloskey should face the suspension of his law license. It looks like the suspension would be for 6 months, at least that's the recommendation, and then he has to reapply and show his character and fitness to practice law again. So he probably would stay suspended until he shows some remorse, shows respect to the legal process and judicial process that he pled guilty to, instead of pleading guilty and then going straight to the cameras to explain that he's still proud of his unlawful actions. Being proud of your unlawful actions is not becoming of a lawyer. Does that make sense? Let me know what you think about this one in the comments below. This is just a complaint. Mr. McCloskey gets to defend himself, so he gets to present whatever amount of defense that he'll be able to put together to this. Pleading guilty, he basically doesn't have much of a defense. So I think if I was in his shoes, I might attack on showing other cases where something like this level of offense didn't get a suspension, but maybe just a reprimand, maybe just a slap on the wrist, a public reprimand. Let me know what you think in the comments below. Thank you for watching. Special thanks to our top supporters in September: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, and Eric Tams. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, or through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.